Ich habe dir...
So just out of curiosity, who's working from home?
Yeah, so actually, how's the situation back there? Because, well, we are still on full lockdown. Actually, the situation got quite worse. So basically, those measures that have been lifted have been put back on. So.
Yeah, sorry to hear. Yeah, I mean.
That's not good.
Yeah, we've been locked up since mid-March.
Wow.
And they have been put back on because there was again an increase in numbers, and you fear separate.
I actually think that initially we took a lot of preventive measures, I think in excess, so we actually didn't get to peak. So by the time they lifted the measures, no one had actually contracted COVID. And then just out of a sudden, we spiraled up. It was crazy.
I see.
I'm back in the office, so it's yeah, we don't have a lockdown anymore. I mean, we didn't have a real lockdown, so we were able to, you know, but
yeah, same here. It was not mandatory.
Yeah. Okay.
Hi, everybody, by the way.
Ah, hi, Alex.
Funny enough, Zoom announces me as Alex, but I don't know how to change that.
No worries. So we waited additional 5 minutes and then we'll start, okay? So, yeah.
It's kind of weird with the Alex thing. Let me see if I can change that somehow. Oh yeah, I can. Check this out.
So just to confirm, we'll allow questions at the end of so after all 4 of you are done, okay? I might, if I have some questions.
So first, we just so there will be no questions in between. So we just.
That's I think that's on us. I mean,
and then there is a whole section of questions for everybody, because we're talking about pretty different things, I guess.
Yeah. So I'll leave it up to you. I think we Veronica, you're pro discussing after we're all done, right?
Well, the thing I fear is that with questions, then you go over time and then you leave very few time for the last speaker if you interrupt with questions after each speaker. Well, that's been my experience. I don't know.
Yeah, that's true.
I'm up for anything.
Fair enough.
Yeah. Okay, 2 more minutes and then we'll start. So Hima, can you please make sure that Veronica can share her slides as she starts with her?
Sure.
Yeah, perfect. Thanks. Okay, I think we should start now. So good afternoon. Welcome and thank you for joining our virtual panel discussion on trends in arbitration. My name is Christoph Kaufmann, and I'm the moderator of today's discussion. This event is hosted by the Berkeley Global Society, and I would like to thank the organizers, especially Hima Moody and Uben Gonzalez Lapos of the Berkeley Global Society, for giving us the chance to discuss arbitration insights today. For those of you who don't know the Berkeley Global Society, quick introduction. It's an international organization founded by Berkeley Law alumni with members from over 100 countries. The purpose of BGS is to share knowledge and connect people from all over the world. For example, in 2019, BGS hosted events in conferences in 30 countries, different countries. So yeah, it's a great network to share knowledge and experience. So let's start. Hi, it's good to see you all. And I thank the panelists for sharing their experience with us. Veronica Esquivel Patiño. We know each other from Berkeley Law. I think we saw each other last time in 2014, so it's been a while. You're a senior associate in the civil and commercial litigation and alternative dispute resolution team of Sanchez Devanny in Monterrey, Mexico. You represent clients in judicial proceedings, arbitration proceedings, and are also the current regional coordinator for Latin America of the ICC, Young Arbitrators Forum, and the current chair of the ICC Mexico's Young Arbitrators Committee. You have participated as a panelist in several different national and international events related to arbitration, and also are adjunct professor in different postgraduate courses. So it's great to have you here. And I know that you will speak about the cost of arbitration, as well as the United Nations Convention on International Settlement Agreements resulting from mediation, also known as the Singapore Convention on Mediation, as well as the Hague Choice of Court Convention. Very excited. So I'll hand it over to you and have fun.
Thank you, Christoph. Thank you also to the Berkeley Global Society and Osborne Clark for hosting this event. I'm very excited to be sharing this panel with such distinguished panelists and speakers. And some of them also former classmates. I had the opportunity to study with Christoph, but also with Flavio. I'm just taking my time to share my slides, and I'll start right over. I think you see it now, correct?
Yes, correct.
Perfect. Okay, so I'll go straight into my presentation. I don't want to take any time from my colleagues who actually are talking on very interesting topics. And well, my topic was basically cost-benefit arbitration, and basically as Christoph discussed, considering the entry into force of the Singapore Convention now in September 2020, and the already existing Hague Convention. I will go into that later. I wanted to start with a brief background on why this subject is relevant right now. I considered it was going to be relevant since last year, beginning this year, but I think it became more relevant with the pandemic. So in Mexico, we have concurrent jurisdiction for commercial matters, both federal and local courts, and here this commercial matters. And what happened is that basically with the pandemic, federal courts suspended activities since March 18th. They're to return until July 15th. And at a state level, courts suspended their activities also, most of them on March 18th. And some of them have already resumed activities with a very limited activity. And the rest of them will return until August the 3rd. So I actually think that this matter of cost has become trendier because as more users have looked towards ADR due to the lack of access to courts at this moment, there's still great preoccupation on what the costs of arbitration are, especially considering that most of these companies are facing economic difficulties at the moment. So getting back to what I was saying about the need of ADR, when we look towards arbitration, and 64% of Queen Mary's International Arbitration Survey agree with me, respondents agree that the most attractive feature of arbitration is enforceability. But also 67% of the respondents agree that cost is its worst characteristic. So the question here for me is, will enforceability remain arbitration's most attractive feature? And this is why I consider the subject relevant at the beginning of the year, regardless of the pandemic. Because while none of the conventions that I'm referring here have the same number of signatories or have the same number of countries party as the New York Convention, which already has 164 to be exact, there's been a gradual approval towards these conventions. The Hague Convention and Choice of Court Agreements, which entered into force in October 2015, includes amongst its ranks Mexico, Singapore, and the European Union, with other countries to follow on a more gradual process, unlike what was seen with the 1958 New York Convention. And on the other hand, the Singapore Convention, to enter into force in September, counts with the ratification of Singapore, Fiji, Qatar, and Saudi Arabia, having been signed already by 52 states. So that being said, what the question would be if the cost of arbitration will be weighted with more attention in relation, or now that we have the alternative of cross-border enforcement of foreign judgments, for instance. So the answer for me is that obviously, yes, it's an alternative out there that's considerable for users, without setting aside the fact that a foreign judicial procedure will bring other considerations to the table, such as, is it actually cheaper? Are national courts viable alternatives? What's the complexity of the procedures? What's the quality? How long do these procedures take? And well, enforcement in numbers. One thing I always say is that we love to see numbers. And for that, I think it's relevant to consider, and I have it on my next slide, the Doing Business report by the World Bank. The 2020 business report kind of ranks countries on different items. One of them is enforcement of contracts. And it basically measures 3 indicators, 2 of them quite obvious: time, cost. the third one, more difficult to measure, but it's quality of the judicial processes. And basically it ranks the countries. And on the 2020 report, we had Singapore ranking in #1 and Mexico ranking in number 43. Why I'm mentioning these countries? Because as I said, both are parties to the Hague Convention. So kind of makes sense to leave it out there as some food for thought. And well, basically the same goes for the entry into force of the Singapore Convention. There's questions such as, is it a viable alternative? What's the spread of states that are party where enforcement can be sought? Also, narrowness of grounds for refusing relief, for example, and if you follow the discussions, Article 5.1e of the Singapore Convention has been widely commented due to the lack of explanation or guidance of when a breach by a mediator will be considered serious enough to enable a party to argue it would not have entered the agreement but for that breach. And also, well, there's no indication given in the convention of what standards will be applicable to the mediator. Regarding standards, well, we know there are no internationally accepted standards of conduct for mediators or mediations, and regulation is left to local law and practice. While in many jurisdictions, mediators must undergo training and will be formally credited, in others, mediators agree to voluntarily self-regulate, and well, there's also those cases where there's no regulation altogether. And well, obviously, I'm not questioning that mediators will surely conduct themselves to the highest standards. The lack of definition could provide, obviously, for a basis of challenge. In the end, the convention provides that signatory states will enforce settlement agreements in accordance with their own rules of procedure. So much will depend in the end on the local implementation processes. And well, I don't want to leave out the fact that mediators will say that, well, mediated settlements are usually complied voluntarily. Actually, I think statistics place a voluntary compliance of mediated settlements in over 80%. And yesterday that I went over this number, I actually found some publications that placed it even higher in around 90%. So well, this is an argument that's always made. We have to keep in mind the fact that a mediated settlement can have obligations that undergo long periods, and well, we cannot predict what's going to happen. Pandemics do happen. So back to the international opinion. In other words, if arbitration's worst characteristic is, well, basically that it's expensive, will this new alternative discussed, and I mean both conventions, play a role in its long-established popularity? And basically, here is where I would like to introduce just a few examples of how arbitration has adapted or is adapting to meet the current times needs and providing dispute resolution methods that can, from a cost-benefit perspective, answer to the concerns on costs. Obviously, these are the ones I'm showing, are just a few of them. Probably my colleagues will touch on other relevant trends. I'm pretty sure they'll be discussing other relevant items. Firstly, I am showing interplay between mediation and arbitration. We have seen this, I wouldn't say as popular, but almost as the norm or rule, for example, for Belt and Road disputes, where in most scenarios, a dispute will involve at least one Chinese and one non-Chinese party, whereas typically Chinese parties prefer a less adversarial approach to settle matters amicably, quickly, inexpensively, and in consideration of the continuing commercial relationship, which I think is very relevant for this kind of projects. The result will obviously has been an interplay between mediation and arbitration with multi-tiered dispute resolution clauses, either providing for mediation followed by arbitration or preserving the option of mediation before arbitrating. Secondly, expedited procedure rules. While upon its conception, arbitration was brought up as a quick, efficient, cost-effective dispute resolution mechanism, over time, arbitral proceedings have become lengthier and more expensive. In a way, expedited procedure rules or fast-track arbitration come return some of these acclaimed qualities to some arbitration proceedings. As you can see, here I'm mentioning some arbitral institutions that have fast-track arbitration or expedited procedure rules, most of which provide for general requirements for any that are consistent in most rules. One of them is the claim amount, or a threshold set for claims. For instance, ICC provides expedited arbitration to apply automatically to arbitration agreements concluded after March 1st, 2017, for disputes under $2 million US. So, and this is where parties have not expressly opted out. Also, most rules provide for strict deadlines. Most importantly, a limit for the award to be rendered. The ICC rules, for example, provide for award to be rendered 6 months from case management conference, while SCC rules, to give another example, provide for 3 months after case has been referred to arbitration. Another thing that these rules, that rules provide is for a sole arbitrator for simplified procedures, which include omitting some stages, elimination of hearings, and well, obviously shorter submissions. Evidently, fast-track procedures have also have been in great part a response to cost considerations, especially for small claims, but still pose complications or have critics that argue on sacrificing of quality, on whether these procedures provide for grounds of challenging the awards, and well, in my opinion, the most relevant, on whether the value of a dispute is actually indicative of its complexity. However, to put numbers on its relevance, please consider the number of expedited procedures administered by ICC since publication of the new rules. What I want to emphasize basically is those automatic applications versus those requests for applications, which kind of show this interest of basically opting in regardless of the threshold. This is talking about the amount in dispute, basically because of the shorter time frames and obviously the preferential fee schedule. I also want to take an opportunity to mention that obviously expedited procedures have not been the only way institutions have addressed the matter of cost effectiveness. There's also institutions that have established sanctions for delays on arbitrators rendering their award with reductions of fees ranging from 3 to 25%, depending on the delay. In other words, expedited arbitration is obviously not the only way the arbitral community is attempting to keep arbitration current and ensure efficiency of the proceedings. There are a lot of notes to parties and guidance provided for parties, tribunals, and institutions to ensure efficient proceedings and therefore reduce costs. So going back to the examples of how arbitration has adapted or is adapting, we can also talk about the rise of national institutions with lower fee schedules or attractive advantages. And here I like to talk about the 2 national institutions we have in Mexico that have become quite relevant in the pandemic. One of them, for example, administers proceedings for small claims in a time limit of 1 month, which is very attractive for some users, and it's quite accessible, especially when there's no access to the federal or state courts. Also, sorry. Another example I had on my list, which I don't know where I left that slide, was artificial intelligence and tools for document review, tools for paperless hearings, video conferencing, online secure digital platforms. I often say that COVID-19 came to quickly eliminate that pushback from attorneys to adapt to a new era. I believe these changes had been available for quite a long time, and we were basically reluctant to adopt them. And basically we were pushed and had to dive right into total use of technologies, contactless everything in just a few weeks, or at least is what happened in my jurisdiction. Finally, another example is increasing promotion of services by institutions such as experts and dispute boards. And in the end, basically, I think what I'm trying to say is that this entry of the new conventions and maybe having enforceability of cross-border judgments or mediated settlements might be an opportunity to see how we are doing things, what can be improved. Basically, if enforceability of awards is the most attractive feature, this doesn't mean, and that's why I'm displaying the other features that respondents of the survey consider relevant in arbitration. That doesn't mean these other features, like for instance, flexibility, cannot be enhanced to produce more, for example, cost-effective procedures, or at least go into those worst characteristics from this same survey and try to bring, for example, costs down or make it more accessible to users. I believe it's a challenge for both users, party representatives, institutions, lawmakers, and the judiciary to focus on tackling this perception that arbitration is expensive, or see ways of keeping this loved dispute resolution mechanism trending. In the end, I think it mostly boils down to how satisfied the user is with what they paid for. So this is like what I like to tell myself whenever I review my Amazon bill. So basically, that's what I wanted to share with you guys today. I hope you found it interesting. Thank you.
Thank you, Veronica. It was indeed very, very interesting. And just to remind you all, we'll allow questions after we're all done with our presentation. So we allow everyone to share his experience for the exact same amount of time. So our next speaker or panelist is Flavio Peter. Flavio is a counsel at Wenger Weli in Zurich, Switzerland. He represents clients in arbitration and annex proceedings. In addition, Flavio is a visiting scholar, lecturer at the University of Zurich since 2015, and author of several publications in his fields of experience. We also go back, Flavio. We've been together to Berkeley Law and sat in class and in Andrew Guzman's class of international arbitration.
Exactly.
So today you will speak about the Lexx Arbitry, the changes to it in Switzerland, and I'll hand it over to you.
Thank you very much, Chris. Thank you very much, Berkeley Global Society and Oscar Clark for hosting this and for having me. It's my absolute pleasure to be here. Of course, also with you guys. I'm trying to set up the screen, so let me quickly see whether that works.
Yes, that looks good.
Okay. Well, today I was thinking about what sort of trends do we have, and gladly, just recently, the Swiss Parliament passed a revision of the so-called 12th chapter of the Swiss Private International Law Act. That was 3 weeks ago. It's been debated for like 2 years, 3 years. The 12th chapter of the SPILA, as we refer to it, is the Lex Arbitri governing international arbitration. Domestic arbitration in Switzerland is governed by certain provisions under the Swiss Code of Civil Procedure. International arbitration is governed by the 12th chapter. The SPILA was from the 80s, so it was like 30 years, or well, soon to 40 years old. It was drafted in parallel to the model law, so it's not an uncitrul model law enactment or replication. It has its own sort of logic, but it's obviously content-wise quite similar. But since it was from the 80s, it was about time to modernize it. And so the aim of the revision was sort of to maintain and enhance the attractiveness of Switzerland as one of the preferred seats for arbitration internationally, but then also to align it with case law and practice in order also to actually increase the user friendliness. There was a lot of things going on that were not really written in the 12th chapter that needed to actually be put to paper, and obviously a couple of gaps that needed to be filled as well. For you, I thought to focus, obviously to give you an overview of certain of those changes, but then to focus on those that may be of international value also for your own practice. So let's see how this goes. So generally, as mentioned, the revision aimed at aligning the SPILA with the practice and case law, for example, that pertains to the remedies available in relation to an arbitral award. There was not only the challenge or the setting aside, as you may call it, of an award. Obviously, it is also possible to have the award revised. So if there's any facts that you become aware of only after the award has been rendered, but that fact or circumstance may have an effect on the judgment itself, you may apply to the Federal Supreme Court for a revision of the award, and you can do so within 90 days of becoming aware of such circumstance. And that was already possible, obviously, but it is now put to paper. Same goes with the correction of an award in case of clerical errors in the dispositive section, or the interpretation of an award if something in the operative part is unclear. Also, same applies to an additional award. So if the tribunal omitted to decide on certain issues that were pleaded by the parties, but simply did not decide on, the party have a right to make an application to the tribunal to render an additional award. That was one of the things, as mentioned. I mean, that was already done in practice, but it was not reflected in the SPILA up to now. The same goes with a need to object in case there's a procedural violation. I guess we would all agree that we are familiar with that concept, as if you do not object to a procedural violation, such objection will be deemed to be waived. And another last aspect, a little bit more trivial, I would assume, is that local courts would give assistance to arbitral tribunals in summary proceedings and not with like full proceedings under the Swiss Code of Civil Procedure. So that is basically what alignment meant, a couple of those aspects. Now, if we stay with the assistance of local state courts, I think it might be interesting for you to know that what has been implemented newly is that local state courts in Switzerland may also give assistance to arbitral tribunals abroad. So this sort of concept you may recall from certain classes that you might have had in Berkeley or elsewhere, and you might have heard of the 28 US Code, section 1782. Which would apply to courts in the US that could assist international tribunals abroad for the taking of evidence. It's about the same notion. However, now what has been implemented in Switzerland is a little bit broader in scope, meaning that local courts in Switzerland could also give assistance to interim measures and in addition to the taking of evidence. What of course you need to be aware of that, for example, if you have an arbitration or whatever, an arbitration in the US that may follow some sort of US style techniques or US approaches to document production, like discovery, you're unlikely to get assistance by Swiss courts because they will apply the Lexx to see what they actually can assist with, and US discovery is certainly not something that Swiss courts are familiar with, and between brackets, much less something that Swiss courts will probably want to support because it's just different in nature. But just for you to know, like there's this possibility to actually then go around to circumvent the usual way until now of judicial assistance that we had under the certain Hague conventions, etc. You can do that now directly based on this provision in the SPILA, in the new provision. Another aspect of the revision of the 12th chapter was that we included specifically also the provision that let's call them statutory arbitration clauses or one-sided arbitration clauses that are contained in testaments or in trusts or articles of association. They are also valid. I think the general discussion that followed that suggestion to actually make it part of the SPILA was really much about the question of consensus, whether there was a valid arbitration agreement if a person, for example, writing the last will, was just including an arbitration clause and the heirs basically had to accept the arbitration clause. Did they voluntarily consent to the arbitration or not? I think that sort of discussion has now become redundant because the parliament actually said, yes, that is sufficient for consent, that is an arbitration agreement. That's one of the things of the novelties. And what is also interesting is in case of pathological clauses, and that would be the second bullet point, if you have an arbitration clause that does not provide for any seat of arbitration at all, or if it provides for arbitration in Switzerland, that might have led to certain problems, particularly if the parties could not actually get their heads together to constitute a tribunal. The question was, where was the seat, which was the local court to actually make a motion to for the constitution of the tribunal. This has been solved in a way that claimant can choose whatever court it does want to go to in Switzerland. So theoretically, if you ever encounter an arbitration agreement saying the parties agreed to settle all the disputes in relation to this agreement by arbitration, full stop, not giving any seat of arbitration, you might want to think about to come to Switzerland. Go to any court in Switzerland, if you have problems with constituting the tribunal, you might go to Switzerland, seizing any court of your choice. And by that, you probably would also designate the Lexx the Lexx arbitry to be applied, making it sort of connected to Switzerland. Now the last feature, and again something for our colleagues internationally, is that the Parliament has decided to allow the setting of side motions, so the challenges of arbitral awards in English language, to go to the Federal Supreme Court. To date, the Swiss Federal Supreme Court did already accept exhibits in English. So if you had an award and the entire arbitration was in English, if you had an award in English, you could obviously submit all relevant documents to the Federal Supreme Court in the original language, but the main submissions, the main challenge had to be in one of the official languages, being like German, French, or Italian. Now this new this new provision will allow parties to actually also submit the challenge in English. That will reduce costs and efforts for translations of certain documents. That would also, and that is probably contra from a Swiss perspective, that would also eradicate the need of Swiss lawyers, because if you're admitted as a lawyer in the EU or in EFTA states, member states, you are also allowed to go in front of the Federal Supreme Court. And if you have an arbitration already in Switzerland, you might as well just go to the Federal Supreme Court. So Chris, Mr. Kirstein, if you want to in future go to the Federal Supreme Court, you can do it all by yourselves. No need for us. And all in English. Obviously, you probably want to recheck whether that is favorable to go in front of foreign courts, which may apply their own parochial understanding of certain rules, but I'll leave that up to you. So basically, key takeaways for you. If you need assistance of local courts for international arbitration abroad, come to Switzerland, no problem. We have no seats of arbitration, no problem, come to Switzerland. And if you want to challenge an arbitral award in English, of course, do it in Switzerland, no problem at all, do it yourselves.
That sounds promising.
Yeah.
Well, thank you, Flavio. That was really interesting. And again, questions will have to be postponed to after we're all done. So let's switch to Anna. Anna Chundai. Hi. You're an associate at the International Arbitration Group of White & Case in Paris. You're focused on international commercial and investment arbitration as well as public international law. Prior to joining White & Case, you've gained experience at the Office of Legal Affairs of the United Nations in New York and the UNCITRAL Secretariat in Vienna and a number of international law firms in China and in France. You graduated not from Berkeley, but from Harvard. That's okay. And yeah, today you'll talk about conducting virtual arbitration hearings, which is quite interesting at the moment, I guess, for all of us. And yeah, I'll hand it over to you, and thanks for being with us.
Thank you, Christoph. Although I did not graduate from Berkeley, but I have to say that I'm affiliated to Berkeley because my husband went to Berkeley last year. He graduated from Berkeley Law last year, so I'm very happy about it. So let me just set up the slide. And so I would like to thank the Berkeley Global Society and Osborne Clark for hosting this wonderful event and giving me this opportunity to share this topic, trends in international arbitration, with other excellent panelists. And let's jump right into the topic. So the topic I would like to discuss today actually continues the discussion of the previous two panel speakers, is the attractive features of international arbitration, which relates to its procedural flexibility and more frequent use of modern technology during the proceedings. I think arbitration may be more ready to embrace changes, such as the use of virtual hearing in the current COVID-19 world. The pandemic is doubtlessly a disaster for our global community, but it also has an unexpected effect of accelerating digitalization and adaptation to modern technology in a wide range of industries. For arbitration, this may be the last puzzle to make the entire proceeding virtual, because as we have all experienced, we are already doing a lot of our work virtually, including communicating with our clients and exchanging documents, and also filing submissions, even for interviewing with the witnesses and experts. And although I agree that conducting in-person meetings and discussions is certainly more engaging and effective, but we now frequently just hold such meetings through video conferencing because it's more efficient and cost effective. And the only occasion requiring the physical presence of all parties involved at one place is the hearing. However, as affected by the pandemic, our ability to travel has been significantly reduced, and full in-person hearings have become almost impossible in the past few months since the lockdown and closing of borders in different regions. So some member of my team have already conducted fully remote hearings in the past few months, and I am scheduled to have one in the coming few weeks. So I think it will be timely to discuss some salient features relating to virtual hearings. First, so I will cover 4 points. First, what are virtual hearings and the relevant regulatory framework in international arbitration? And second, what are the considerations for a tribunal to hold a virtual hearing? And third, how to ensure due process in virtual hearing. And finally, what are the practical considerations for conducting a successful virtual hearing? First, let's look at the definition of virtual hearings and the relevant regulatory frameworks in international arbitration that provide the legal basis for conducting virtual hearings. A virtual hearing, as you can see here, of course, we know what it is, and it's a hearing where 2 or more locations interact simultaneously by audio or video transmission. Of course, usually through video. And there are 2 ways for semi-remote hearings. There is usually 1 main hearing location and 1 or more remote locations. For example, we can examine a witness or an expert remotely because they cannot physically travel to the hearing venue due to certain restrictions. So this is actually relatively common, and we have done so in many hearings already. And as Professor Maxi Schreier recently wrote, remote hearings are nothing new, but the COVID-19 crisis has forced international arbitration out of its comfort zone. So the second type of virtual hearing is the fully remote hearings, and all participants are at different locations. And my discussion today mainly focuses on the fully remote hearings. So the currently, due to COVID-19 pandemic, even the council teams may not be able to gather physically together at one place. And so what is the basis for holding a virtual hearing? As we know, all arbitration rules provide that parties have the right to oral hearings. For example, Article 25.2 of the ICC rules provides that the arbitral tribunal shall hear the parties together in person if any of them so request, or following such a request, it may of its own motion decide to hear them. So here I underlined the use of the words together and in person. So some have argued on this basis that virtual hearing is therefore not possible because it requires the parties to attend their hearing together in person. But this is, in the view of many, not the correct reading of the ICC rules. If you look at other linguistic version of the ICC rules, they do not necessarily contain the wording in person. And also the ICC has clarified that virtual hearings are possible under its rules. In its recent guidance, the ICC notes that Article 25 does not require in-person hearings. And this article is intended to provide opportunity for live adversarial exchange, and a hearing can be conducted in person by virtual means. None of the other articles in the ICC rules can be read to require in-person hearings, although tribunals in a particular dispute may decide that an in-person hearing is necessary. So I refer again to Professor Maxi Schreier. As far as she's aware, there is no arbitration rules or national statutory rules that mandates or prohibits virtual hearing. But it is indeed recognized that most of the national statutory rules do not address the issue of virtual hearing. And some parties may insist on physical in-person hearing in order to delay the arbitration proceedings. This is presumably raised more often by the respondent in a case. In this circumstance, parties may have to make submissions to the tribunal to request or reject or object to a virtual hearing. So this leads to my second point. So what are the considerations for a tribunal to order a virtual hearing in the event that the parties cannot reach an agreement? So in the case of objecting to virtual hearings, various submissions have been made. For example, a party may argue that seeing the witness in a serious case is vital, and the importance of live interaction between counsel and the tribunal and between tribunal members themselves cannot be overstated. So under all the main arbitral institutional rules and national statutory rules, tribunals have the discretion to make the hearing happen, and counsel and parties are expected to cooperate. So in consideration whether to hold a virtual hearing or not, a tribunal has to balance two conflicting factors. On the one hand, there is a duty to conduct the arbitration as expeditiously and efficiently as possible. So for example, if the postponement of the hearing has the potential of introducing harm to one party, this may tip the balance towards a virtual hearing. And on the other hand, the parties have the rights to equal treatment and the rights to be heard. So here, the UK and Singaporean courts have held that virtual hearings do not in themselves deprive the parties' rights to equal treatment. It is indeed a case-by-case analysis. For example, when the parties do not have the same access to technologies and one party cannot effectively participate, this may affect one party's right to equal treatment and to be heard. And some institutions have already set out the considerations for tribunal in determining whether to proceed with a virtual hearing or not. For example, the ICC refers to factors such as the nature and length of the hearing and the complexity of the case and the number of participants, and whether there are particular reasons to proceed without delay, and whether rescheduling the hearing would entail unwarranted or excessive delay, and the need for the parties to properly prepare for the hearing, and whether the awards will be enforceable. So this leads to the next point of my discussion. How do we ensure due process in a virtual hearing? So the first common issue that many are concerned about relates to witness examination in a virtual hearing. So there is a real risk of witness coaching when it comes to virtual hearing or remote examination of the witness. So for example, there's an anecdotal story that a colleague shared with me that many years ago, he conducted cross-examination of a witness through video. So before he started, he asked the witness to turn the camera around and show him the surrounding. So my colleagues suddenly heard noises of footsteps and door slamming in the room before the witness turning the camera around. So we do recognize that witness coaching is a well-founded concern. However, it is also agreed that this concern may be slightly exaggerated, and because our modern technology indeed allowed us to examine the surrounding and have a closer and clearer view of the witness. So this makes it easier to spot any interference with the witness testimony, and whether the witness is cheating. If there is a real and serious concern of witness coaching, there will be mitigating methods, of course. So another important issue is the validity and enforceability of an arbitral award when the hearing is held remotely. It has now been widely agreed that as long as there were no demonstrable due process concerns, no national courts would set aside an award solely on the ground that the underlying hearing was held virtually. And in a recent webinar held by the SEC, it is noted that according to an investigative study, there is no one single publicly known court decision where an award has been set aside on the basis that all or part of a hearing was held virtually. So in order to ensure due process of the hearing, it is also critical to make sure that the virtual hearing runs smoothly so that the parties have an equal opportunity to make their case in front of the tribunal and are not disadvantaged by how the hearing is conducted. So lastly, I would like to briefly address some practical considerations for conducting a successful virtual hearing. We have to admit that virtual hearing is still new to us, and when we are not familiar with the relevant logistics, it is certainly more complicated for planning. But I believe that it is just a matter of habits and adapting to the relevant technologies. So first, it may be desirable to agree on a protocol with the tribunal and opposing counsel in advance of the hearing regarding the use of audio and video feeds, raising objections and the manner and methods of interrupting anyone who is speaking. And also make sure that you have the backup plan when the technology fails, so that we know how the parties will communicate with the tribunal. This is also to prevent ex parte communication with the tribunal in order to ensure due process. And second, it is strongly recommended by many colleagues to run multiple rehearsals before the hearing. So we need to make sure that all the equipment for each participant has been tested well in advance. If possible, organize a couple of short trial runs with all participants. This will ensure that all of them have had an opportunity to familiarize themselves with the technology. And another related tip is to adjust hearing timetable accordingly. Because we need to build in a time for dealing with technology failure and to accommodate participants in different time zones and to have more hearing breaks, because people's attention span actually seems to be shorter in a virtual setting. And to conclude, I would like to share with you a recent report from my colleague who just concluded a virtual hearing. I quote, "We had our virtual closing hearings Tuesday and yesterday, 1 day and a half of counsel submissions, and a half day of experts conferencing with participants sitting in Sao Paulo, New York, Atlanta, Birmingham, DC, Santiago, Germany, Italy, and Paris, of course. It was held in WebEx, via WebEx, organized by White & Case, and everything went very well. It took multiple rehearsals over 2 weeks and an IT vendor coming in to make sure that the WebEx worked well for everyone, but picture and sound were eventually perfect thanks to huge efforts put in by the team. Our IT colleague even had to get on the phone several times with 2 of the arbitrators to assist them with technical issues. And I learned that restarting the computer and internet box resolved 90% of all issues. I'm still of the view that nothing replaces an in-person interaction, but this was pretty close to the real thing." End of quote. So will there be a paradigm shift towards virtual hearing, or would fully remote hearings become the normal in the future? And I think the current crisis forces us to engage in this exercise. And I think both physical hearings and virtual hearings have their merits and deficiencies. So I leave it to all of you to consider and think about what your preferences would be. Thank you.
Thank you, Anna. That was really interesting and a topic that affects us all. Again, we'll allow questions after Alex's speech, so we're all done, and then, or you're all done, and then we can discuss. Alexander Kirstein, you're a partner at Osborne Clarke, heading the practice group Dispute Resolution. You act for international companies in all types of commercial disputes, mainly, of course, with international cross-border dimension. You have experience in ICC, dis and ad hoc rules or arbitrations, and you're the founding member of the International Arbitration Group of Osborne Clarke, which handles large cross-location international arbitration proceedings. We're very happy to have you here today, and I hand it over to you. And I know that you will talk about a very interesting, controversial case, which I'm excited to hear about.
Thank you, Christoph, and also many thanks to Berkeley Global Society. Always a great pleasure to work with you. So indeed, what I want to do today is talk a bit about latest trends in arbitration in Germany. There were two court decisions that might have a significant impact on arbitration in Germany, including Germany-based international arbitration. There was one decision of the German Supreme Court and one decision of the Frankfurt Court of Appeal, which obviously Frankfurt is a quite prominent spot for arbitrations. So the Frankfurt Court of Appeal decisions usually have some more impact than decisions of other courts of appeal. And both decisions were coincidentally rendered on the same day, which is the 16th of January, 2020, so quite current. One topic that both of these courts concerned themselves with, or were concerned with, was the right to be heard in court as a ground to vacate a court decision. In the case of the Supreme Court, it was the decision that was affected was the decision of the Court of Appeal. And I hope it's not confusing, but it was the Frankfurt Court of Appeal that was the instance before the Supreme Court. But that's also just a coincidence. But in the Frankfurt Court of Appeal decision, it was an arbitral award that was the center of this court decision. So the right to be heard in court is a constitutional right in Germany, as in many countries. And I believe there are very many aspects of this constitutional right. But one of them is that the courts have to express in some form, and that extends to arbitral tribunals, that they took note and considered both parties' relevant arguments when rendering a decision. If they don't do so, their decision runs the risk of being vacated, or in case of an award on appeal, or in a case of award upon an application to the competent court, which in Germany are the higher regional courts, the courts of appeal, like the Frankfurt Court of Appeal. So historically and typically, trying to vacate an award on the ground that, the parties' rights to be heard have been violated, especially been violated because the legal arguments or the relevant arguments weren't reflected in the award, are, I would say, seen as an option, but usually it is very difficult to get an award vacated on this ground. But here come the Supreme Court and the Frankfurt Court of Appeal. So in the Supreme Court case, the underlying facts were that parties entered into a supply agreement for a certain period. I believe it was 2016 to 2018, and then later supplemented this agreement by a second And only in the second, in the supplement agreement, they agreed on an arbitration clause. So the claimant filed a request for arbitration also concerning issues of that initial supply agreement that did not contain an arbitration clause. And at the same time, the claimant filed an application with the competent Frankfurt Court of Appeal to get a decision that the arbitration is admissible, also in respect of issues pertaining to the initial supply agreement. The Frankfurt Court of Appeal agreed and said, yes, the arbitration clause extends to that earlier supply agreement. But on appeal, the Supreme Court revised that decision. And it literally on the ground that it says about the Frankfurt Court of Appeal decision that the right to be heard in court causes an obligation of the court to consider all relevant arguments of the parties and reflect this in the reasons of the decision. So in the case at hand, the Higher Regional Court of Frankfurt in the Supreme Court's opinion had not sufficiently shown in its reasoning that it considered all the arguments that in that case the defendant had brought forward in relation to why this arbitration clause should not apply to the supplementary agreement. The Supreme Court then handed the matter back down to the Frankfurt Court of Appeal, which is to then enter into a decision on remand. This decision has not yet been published, but I think it will be interesting to read it. The second case, the Frankfurt Court of Appeal case, concerned a case where an insolvency administrator is quite a prominent case. It apparently, although the decision was redacted, it apparently concerns the prominent ACVA insolvency. So the insolvency administrator brought an arbitration against the former shareholder of the insolvent company. And the decisive point was the question whether a contribution in kind that shareholder had made to the later insolvent company reached its nominal value. So in the course of the arbitral proceedings, an expert report was commissioned by the tribunal, and the parties disputed whether or not the expert used the correct figures for the result it came up. The liquidator lost the arbitration, so an award was entered against him, basically on the crucial grounds that the expert had found in his opinion. So then they challenged the award, and then in a 57-page long decision, which is very, very unusually long for German courts, the Frankfurt Court of Appeal vacated the award, again, for violation of the right to be heard in court. The court found that the arbitral tribunal had not sufficiently considered arguments raised by the claimant in respect of that expert report. If you look at the decision, it's pretty much about numbers. In particular, the claimant had argued that the expert used figures that were outdated at the relevant time. And that the tribunal had even repeated these arguments that the insolvency administrator brought forward, but in the factual section of the award. But according to the Court of Appeal, they did not consider them in sufficient depth in the legal reasoning part of the award. So the arbitration that was underlying that case went on since 2009. So the Frankfurt Court of Appeal did not shy away from vacating an award, which the parties had for sure spent millions on to get to that point. And it took him 10 years of time. And, you know, just by giving the reasons that I just mentioned, the Frankfurt Court of Appeal struck it down. So I think that is a pretty stiff statement. as far as takeaway points are concerned, I'd say as far as the Supreme Court decision is concerned, the first takeaway point obviously is draft your arbitration agreements properly. Obviously, the arbitration agreement that was underlying the dispute did leave some room for interpretation as to whether or not it should apply to that earlier supply agreement. So obviously, it's always helpful, if not highly recommended, to draft your arbitration agreements clearly as to their scope of application. If you don't want to go to Switzerland and help Flavio and his courts and colleagues to get some additional business. But both decisions, I think, lead to the takeaway point that, in my view, that they're warning shots to both the public courts and the arbitral tribunals to really carefully the parties' arguments on decisive questions. It will not just do to repeat the arguments in the factual part of the award, which I think is quite standard. That you read a lot. But then if you go into the legal reasoning, you barely, I find, at least historically, there is always doubts that, in a complex dispute, that really the court or the arbitral tribunal really did consider all the relevant arguments. So I think in the future, it remains to be seen, even if these two decisions started a trend that the courts do scrutinize arbitral awards with a higher standard than they used to. But I would not exclude that. At least I think the arbitral tribunals are well advised to make sure that they do reflect the parties' decisive arguments in the awards. So, and for sake of completeness, the Frankfurt Court of Appeals decision has been appealed again to the Supreme Court. So the Supreme Court will rule on that case too, and it's going to be very interesting to read that decision. So the Frankfurt Court of Appeal in this decision of 16 January 22 addressed a second issue. It's quite interesting, and that is the issue of including a dissenting opinion in the award. So apparently, in the underlying case, one of the arbitrators wasn't happy with the majority decision in that dispute, and they included a dissenting opinion in that award. And in this decision of 16 January 2020, the Frankfurt Court of Appeal took the liberty to state that a dissenting opinion violates public German policy. So the point is that the court did not have to conclusively rule on that issue because it vacated the award anyway for the reasons already explained. But as you can imagine, that decision made a lot of noise. But the reason which the Frankfurt Court of Appeal gave for its view is that the internal deliberations of the arbitral tribunals are confidential, and that this confidentiality is protected by fundamental principles of German law. So according to the court, it's necessary to uphold these principles and to protect the impartiality and independence of the arbitrators. And therefore, neither the arbitrators nor the parties have the right to derogate from these principles. So thus, on the back of that, the Frankfurt Court of Appeal decided that a dissenting opinion violates German public policy. I guess mainly the reason for the upset that decision has caused in the arbitration community is that it potentially and obviously gives one of the arbitrators in a 3 or more arbitrator tribunal a means to bring down an award or make it prone for being vacated. If they maybe not included in the award, but then just by by email or whatever means they have, come up with the dissenting opinion. And that obviously is a threat. And what can you do about it? Takeaway point. There are two options mainly. One is that a party agreement that the dissenting opinion is allowed. That is generally seen as possible. But the Frankfurt Court of Appeal said that the impartiality and independence of the arbitrators is not at the party's discretion. So in my view, that excludes the option to overcome this issue by party agreement. The only other way I see to make sure that you exclude that risk for an award in your favor is that at the beginning of the arbitration, when the arbitration tribunal constitutes, you make all of the arbitrators aware of this decision and simply prohibit dissenting opinions, and potentially even include provisions in an agreement with the arbitration tribunal that any arbitrator who comes up with a dissenting opinion is liable to the costs. If then on the back of that, the award is vacated. And go back to the Frankfurt Court of Appeals case, so that was a 10-year arbitration that potentially would have also, if not for the violation of the right to be heard in court, that potentially the Frankfurt Court of Appeal would have vacated on the ground that it included a dissenting opinion. So that is basically 10 years of arbitration, millions of euros or dollars or what it was down the drain. So I personally would make sure in the next piece of arbitration that comes across that we clearly address this issue and make sure that none of the arbitrators comes up with a dissenting opinion. Good. I mean, I mentioned earlier that the Frankfurt Court of Appeals decision is in front of the Supreme Court right now. And I'm pretty sure that the Supreme Court will also address this issue of dissenting opinions. I think likely revise the Court of Appeals view, if only for the reason that this is simply impractical. But you never know. If the Supreme Court backs up this view of the Frankfurt Court of Appeal, I think we'll probably see some revisions to at least the rules of the DIS, or at least it is strongly advisable to take precautionary measures to prohibit arbitrators to come up with dissenting opinions in Germany. That's that. Yeah, I think we have the round of discussion now.
Correct. Thank you, Alex. That was really interesting. So we have a few questions from the audience, but before we go to that, I would let you ask some questions if you have any.
You mean us?
Yes, the panelists.
Yeah, I mean, I was taking some hectic notes when Flavio spoke about these new laws in Switzerland. I think it's quite interesting. So one of the questions I have is, you typically don't. Let me say that if you have sufficiently sophisticated clients, as most of our clients are, you hardly see an arbitration clause, a well thought through arbitration clause that doesn't provide for a seat. But sometimes you have disputes about whether an arbitration clause exists at all, or what exactly the parties agreed on and wanted to have covered by the arbitration clause, as shown by this Frankfurt Court of Appeal decision. The Supreme Court decision. So I was wondering, what could it be an option that if you have a disagreement between the parties, if there is a valid arbitration clause between them at all, would you say that is that is a situation where you could come to Switzerland and then at least increase the likelihood that the courts firstly assume jurisdiction over the case at all, and secondly increase the likelihood that they find that there is an arbitration clause.
Well, if that arbitration clause, again, if it doesn't include any seat, any determination of a seat, then I would say yes. Then you could probably try to make it, well, let's say pending. In Switzerland, it's probably the wrong word, because usually you would probably have institutional rules, so you would have to go over the institution. But you would argue, yeah, seat of arbitration is Switzerland, and like you would probably try to constitute a tribunal on the basis of what has been done. And in that case, yeah, you could hope that the arbitrators take a favorable approach to it. But in the end, I mean, that I'm not sure whether that should be the #1 criteria to go to Switzerland, just to increase that sort of a likelihood. Because to my perception, maybe, I would assume that most of the countries or evolved countries do have a favorable view on arbitration, that if there is an arbitration clause, you would leave it to the tribunal to decide in that sense. And probably most of the tribunals will also look at it favorably, which is one of the inherent conflicts of interest of the arbitrators, in my view. But that's a different topic for probably a whole different session.
Do you have a procedure in Switzerland, as we have in Germany, where if there is a dispute about the admissibility of the arbitration, that you can go to competent court of appeal, as it is in Germany, to get a declaratory decision on whether the arbitration is admissible, in order to clarify whether it is or not before you enter into a lengthy arbitration process?
Admissible in a sense of whether the dispute would be arbitrable?
Yeah.
No, but yes. we do not have a specific procedure for that, and it's certainly nothing official. But if you want to be smart or a pain in the ass for the other party, you would probably seize the courts, just whatever court that actually fits you. Bring the dispute to that court. On the question of arbitrability, that court has full cognition. So you would actually have to dispute on the arbitrability with full cognizance, with full scrutiny before that court. That's different as to the question whether there is an arbitration agreement, as you maybe probably have the same sort of rules. If there is an arbitration agreement, that should go to the tribunal, same as Article 2 of the New York Convention, paragraph 3 implies, the tribunal has competent. But you could actually try to do it. Go to seize a state court, claim that this has nothing to do with arbitration, it's not arbitrable, and try to be lucky.
Okay.
We're currently doing something like that.
Okay. Yeah, we have a particular kind of proceeding that where you can go to the competent court of a higher regional court that's competent in these matters, and ask for a clarification if there is a valid arbitration agreement that the parties are bound by. You can do so until the arbitral tribunal has constituted. Once they have constituted, that proceeding is not an option anymore.
Interesting.
Yeah, that was the type of proceeding that was underlying the Supreme Court case I was talking about.
Okay, interesting.
Any other questions?
Well, I had one question as regards Alex's presentation with regard to the case of the dissenting opinion. I mean, that sounds so outrageous to me, but because it just deviates from the understanding that we know here. Do you think there's any chance for actually making a claim against the arbitrator for liability? Any arbitrator,
Well, I think if you, unless you have an agreement between the parties and the arbitral tribunal that a dissenting opinion is prohibited, and you find and you even agree on some form of damage claim, a clause that allows damage claims, I think you'd probably not be able to make a damage claim against the arbitrator. That, I think, makes the decision of the Frankfurt Court of Appeal so difficult, because I mean, well, in fact, but to be fair, come to think about it, if you can prove that the arbitrator knew that the decision could be vacated just on the ground that this particular arbitrator issues a dissenting opinion, and the arbitrator did that to allow his or her party that appointed him or her to vacate the award, I would think under German law we would find ways to actually make a damage claim. Yeah.
I mean, I may be wrong, but it seems to me that this decision also does away with the argument of a duty to render an enforceable award, because obviously if you are allowed to make a dissenting opinion, which according to the court is not hinders the enforceability, that must sort of imply that there's no duty to render an enforceable award.
Yeah, well, it would then be a violation of the arbitrator's duty, right? But then still a question if you could claim damages, if you have any leverage to really bar people from doing that.
Yeah, well, 10 million down the drain, as you called it. Good start there.
I mean, it is, right? They can start it. So yeah, I think, I mean, we'll see. The Supreme Court is going to, I think, say something to this. And by the way, there may be 2 points to note about this decision. First is that the Frankfurt Court of Appeal says that the dissenting opinion violates German public policy. That doesn't mean it violates the international public policy that is applied in Germany. So I think if it's a foreign award, you could not use this decision to say it's not enforceable in Germany. So this is, I think, at least limits the decision or the impact of the decision to Germany-based arbitrations, which is enough already. But I think there is a good chance that the Supreme Court is probably going to say something to the dissenting opinion issue, especially against the background that also German literature, and I think also in the reasons that were given by the legislator for certain provisions on arbitration in Germany, it was thought that everybody thought that a dissenting opinion is possible. And Frankfurt Court of Appeal thinks otherwise. You're on mute.
Thanks. I have one more question for you, Flavio. At the beginning, you said that the new Lexx Arbitry constitutes the case law that you've had in Switzerland for quite a while. Would you say that the new law allows more interference by the Swiss courts, or does it even lessen the ways the Swiss court can interfere or set aside an award?
It does not increase any level of interference. We would probably call it assistance, and obviously, like assistance for interim measures, assistance for taking of the evidence. That's just upon application of one of the parties or both parties or a tribunal. So as to the level of interference, nothing has changed, because whatever sort of remedies that were now put on the new revised text, those were already existent. And the challenge itself has not changed. So the grounds for setting aside an award are still the same. So no, there's, in my view, there's nothing nothing new in that regard.
Okay. So if you don't have any other questions with regards to the presentations that you've gave, then I would read to you two questions that we have from our followers on the Zoom or in the Zoom chat. There's one question that says, how do you see the implementation of arbitration clauses in the so-called smart contracts? And generally speaking, what is your opinion on the recent trends in smart contracts and their intersection with arbitration law? I'll leave you to it.
I honestly have to say, one would have to explain to me what exactly is meant by a smart contract. Most contracts I read are not smart.
I think the meaning here is smart contract. I think the smart contracts that are kind of based on a machine or produced by a machine. That's my understanding. Please let me know if I misunderstood this.
I'm happy to leave the floor to Vero or Anna if you want. I just have very little advice on that. In my view, primarily we had discussions here when this popped up like a year or two ago as to the formal validity. That was certainly an issue, whether like arbitration clauses in smart contracts or on blockchain would fulfill the requirements of the formal validity. I guess if you are, again, in favor of arbitration, you would say yes, because you can somehow replicate it in text. Okay, fair enough. I would also assume that the consent requirements, or whether there's an agreement on arbitration clause, that would also be given. And I guess there was a question on how to actually enforce those sort of smart contracts. And there, I thought the entire controversy or discussion that was held in like 2 years back maybe came to a standstill. I'm not sure whether that actually has to do with the trend of blockchain and smart contracts somewhat lessening, but maybe that's just my perception. So I'm happy to hear what you have to say.
Well, I think from a German legal perspective is always a question as to any contract that you enter into, including an arbitration agreement. If you can prove that there is a consent by the parties that they wanted to refer a matter to arbitration, aside from certain formal requirements that also have to be met. But if you have a fully digitalized contract, it's sort of in an automatic way, was concluded in sort of an automatic way, I see a potential issue with that.
Anna, Veronica?
Yeah, for me, I think I agree that there might be a problem with consent, and also I think under different national law, there might be different requirements for the validity of arbitration agreements. So I think, you need to somehow, you can't use, there's no one model fits all, I guess. You need to kind of tailor the arbitration clause in order to have the validity in different jurisdictions.
You also, I think a lot of these contracts were probably concluded with consumers. And of course, that comes with additional challenges when it comes to meeting the formal requirements for an arbitration agreement. If that arbitration clause is included in the same digitalized contract where you have the core contract, the commercial terms, you might run into the problem that just because of that very reason, the arbitration clause with a cost, or the arbitration agreement with the consumer is not enforceable. We were actually, a couple of years ago, we were wondering if we could do something along these lines in a case where a client of ours, a company that has very many companies that it cooperates with, or that it sells product to globally, if we could come up with some sort of digital solution for their arbitration clause, including also then find ways to come up with automated requests for arbitrations for payment claims. So I believe that is something that's possible.
Veronica, you wanted to say something?
Yeah, no, basically following on what Fabio said, I agree the consent, it's important, well, or the where it would turn on, but also the in writing, because I think, well, at least, and as Anna also mentioned, that under Mexican law, I think that in writing evidencing the formal requirement would be quite difficult to evidence. I don't know. I think that once we start seeing it in practice, and obviously, as Flavio mentioned, analysis on this has kind of stalled, but we would need to see it in practice to see how or where courts go at.
Okay, thank you. One more question. How do you see enforcement of awards based on pathological clauses in other jurisdictions with zero tolerance for such clauses? Sounds let me know if you have any. I can't really understand. I mean, I do get the question, but it depends on the country, I would say, right? It's hard to tell what.
Very much.
Yeah.
If I'm not mistaken, but please correct me if I'm wrong, I do not have the text of the New York Convention before me. I thought the question of validity was like under Article 5 and in conjunction with Article 2, subject to the law where the award was made. Though I'm not sure, but I thought it was where the award was made. So if the law of the seat considers a pathological clause as valid and the tribunal would confirm jurisdiction on that basis, you should be able to enforce it under the New York Convention. But that obviously always depends on the perception of the local courts. If I mean, of the local courts in the enforcement country, if those local courts have a favorable approach, then fine. If they also apply the New York Convention by the wording, then that's good as well. But we all know that there's some jurisdictions that have their own interpretation of the New York Convention. So I guess that, well, that's my view on this section.
Any additional comments? No. Okay, then the last question, and I don't know if we can, if you can contribute to that. What is your point of view regarding trends in arbitration in South Asia?
So for me, what I have observed is that I guess the trend of arbitration in South Asia, it's not different from the trends maybe in other regions. What I see is that there is a divergence of arbitral institution, which means that there are actually a lot of local centers. There's like a growth of local arbitration centers, and there is a kind of a growing diversity in international arbitration. But I don't think I could say much about the legal developments in those regions.
Okay, thank you.
Yeah, totally. I think very similar to the experience in Mexico, Central and South America, the proliferation of national institutions that have been administering or are actually administering arbitration, as opposed to the well-renowned international institutions that have been doing in the past. So, well, basically, just like Anna, I couldn't issue my opinion on the other items, but at least this is what I've seen in my region, and I think it kind of compares to what Anna just mentioned.
Yeah, I think especially in times of the COVID-19 crisis, where the public courts struggle for the fact alone, at least in Germany, that oral hearings or in person are mandatory. That makes more people aware, or even that leads to a further shift towards arbitration in the business community. And I think when you look at arbitration, and I think it is even one step ahead of litigation, in the sense that it very quickly was able to adapt to the situation. And as Anna just described in her presentation, they're fully blown hearings by video conference with many participants. We just had a similar experience, by the way, and so I fully agree with what you said, Anna, and it's the preparations are very important. But if you get that right, you'll experience that you actually can hold quite complicated hearings just by video conference, and that in many regards, I personally find they're even better than when you meet in person, because the preparations are different. They're and you have a different focus. If you have a video conference, you just focus on one person, the speaker, and you have them like on your screen. That's different from being in a room together, where your focus is certainly on the person who speaks, but you take a lot more in because you see more. I don't know if that makes sense, but I had that feeling when we examined an expert by a video conference. That was a pretty tough thing for the expert, and you could physically see that. Like you could see how he was physically struggling with the questions and answering the questions. So I thought it was quite an interesting experience. So coming back to the point, I think the way that arbitration could adapt to the crisis quite quickly, and could provide means to resolve your disputes quickly. I thought it was quite astonishing and quite what's the right word? A confirmation that arbitration is just a very, very important and very helpful tool for anybody who needs to have their disputes resolved.
If I might add to that we have a good and strong connection to India. And we know that arbitration is a trend in India, and that we've been to a conference in November in 2019, and we noticed that arbitration is, and it's of course promoted by Modi, but it's helping the people to solve their disputes, because the local courts are just not capable, because of the caseload, to handle all the disputes. And so the people are turning to arbitration to resolve their disputes, and that's I would say that's a trend, at least in India.
Locally, though, like it's in India, nationally, they promote arbitration a lot, and I think they, for the reasons you pointed out, it is a necessity even because the courts are so overburdened with cases. Their dockets are overly full. But as we also learned, international arbitration, or India is a doubtful place for international arbitrations, as a seat for international arbitration. I'll probably stay out of India for international arbitration. Go to Switzerland or Germany.
Or Mexico, or France.
Hong Kong.
Oh, okay.
Or France, of course.
Great. So thank you all very much. I think it was a very interesting and helpful discussion, and it was great to hear from you and all the experience that you've gained. And yeah, I think that thank you all. Again, thanks to BGS, and all the best.
Thank you very much, guys.
Thanks very much.
Bye-bye.
Bye.
Thank you. Bye-bye.
Bye-bye. Emma, are you here? Oh, we still party. Yeah.
Yes, sir.
Oh, let's say hello. I will say hello to. Hello, Alexander. How are you?
On YouTube, I think we need to change.
Yeah. So we can, yes, you can stop YouTube. We can stop everything. Thank you, Alexander. Thank you. You were in the same room.
No, yes. Well, he was next door, and I could hear him. I could hear him